First of all, I would like to thank PLEA for inviting me to give a guest lecture on this topic, which is an integral part of the criminal justice system. The topic which is given to me today is test identification parade. So, as the title suggests, it means ascertaining the identity of the accused by testing the witness. So, test identification parade is ascertaining the identity of the accused by testing the witness, by testing how he is trustworthy, the statement given before the police officer, whether that is true or whether that is false. So, this is one way to ascertain whether the statement given before the police officer matches with the description or the description given to the police officer, and the statement recorded pursuant to such description matches with his version. So now I was told that most of the audience here is law students. So therefore, I'll give you a little bit just about the criminal system. So as far as the IPC and CRPC is concerned in India, how the police machinery is set into motion. The police machinery is set into motion once if a person goes to a police station and he registers an FIR, which is registered under section 154 of CRPC. Once the FIR is registered, now there are two types of complaints. One is the private complaint and second is the FIR, which we call as first information report. So this private complaint, any complaint under CRPC is a private complaint and is defined under section 2D of the CR. So private complaint, if the police officer fails to take the cognizance of the complaint which is filed by you, then a common man will have a remedy to apply before the concerned magistrate, under which a 156(3) direction can be obtained from the magistrate directing the police officer to register the FIR. So this is one of the way, but we'll talk about 154, in which first information report is registered. Now, when a person goes to a police station with some grievance, an FIR is filed by the police officers. Once the FIR is filed, what is the remedy available to the accused? Either he can go for anticipatory bail, or he can go for, if he is arrested, he can go for regular bail. Now, if suppose he is arrested, then it is mandatory on the police machinery to file the charge sheet within the given prescribed time as per the offense. So in some cases it is 60 days and in some cases it is 90 days. So it is mandatory for the police officer to file the charge sheet, which is under section 173 of CRPC. Now, if the charge sheet is filed on, suppose, on 91st day, then the accused is entitled for default bail without going into the merits of the case. So this is a mandatory provision. Now, once the charge sheet is filed, now the investigation during the investigation, what all evidences are collected by the prosecution, because it is a one-sided. It is on behalf of it is on the insistence of the complainant, and accused has no role to play. He is not privy to the documents of the investigation till the charge sheet is filed. So therefore, what are the evidences? Suppose in a case of a murder, what are the evidences which needs to be collected by the investigating officer? Is first the statement, whether the case is substantial or whether the case is corroborated. Now these two concepts are very important. What is substantive evidence and what is corroborative evidence? Now, for example, A assaults B in front of C and C knows A. Then in that case, it is a direct piece of evidence wherein C says that A has assaulted B. So this is called a substantive piece of evidence where no corroboration is needed. Now, what are corroborative evidences? Corroborative evidences are also called as circumstantial evidence. For example, A assaulted B and C saw B running away from the place of incident, and C is unknown, A is unknown to C. So in that case, in this scenario, it is a corroborative evidence. It is a case of last seen. It is a case of the accused running away. He has not witnessed the crime scene. So as I said, if a murder case is taken in hand, then in that case, the police officer has to investigate first the witnesses. He has to record the statements of the witnesses. Second, he has to, if in cases of 302, he has to do the post-mortem report. There are various panchanamas: inquest panchanama, memorandum panchanama, search panchanama, house Panchanama, recovery Panchanama, etc. These are also formed. These all documents forms part of the charge sheet. Then there is forensic report. Now one of the integral part is also test identification parade. Now why this is important? Test identification parade is not a substantive piece of evidence, but it is a corroborative piece of evidence. So as I said, it suggests and it means that ascertaining the identity of the accused by testing the witness. Now, the idea of parade is to test the veracity of the witness on the ground on the question of capability of identity from among several person, an unknown person whom the witness has seen in context of the office. Now, this test identification parade can be seen mostly in cases of dacoity, riot, rape, murder, etc. Now, what are the purpose and object of the test identification parade? So, the test identification parade, one of the objects or the purpose is to prove or to disprove the guilt of the accused. Also, as you all know, that this is in identification of accused is one of the important factors in criminal trial. There is the burden of proof is always upon the prosecution. In cases of murder, in cases of half murder, you can say, or in cases of grievous injuries, the burden lies upon the prosecution, and the prosecution has to prove its case beyond reasonable doubt. So therefore, this a piece of evidence, this test identification is a corroborative evidence to substantiate the allegations made by the victim or to prove the case of the prosecution. So it is forming the link between the actual offense and the accused. Now this test identification is an integral part of criminal investigation. So what about the admissibility of test identification parade? Now admissibility of test identification parade is governed under section 9 of the Evidence Act. I will not go through the sections. I'll give you a very basic and straightforward explanation to everything. So it is governed under section 9 of the Evidence Act. Now, what is section 9? Section 9, in simple words, makes the identification of accused and properties admissible and relevant facts in court of law. But there is no specific provision to direct the suspect to be present before the court. So when this section 9 was introduced, there was no provision wherein a court or the investigating officer can direct an accused to call him for to test him for to call him for the test identification. Now with the amendment in 2005, section 54A was introduced, and wherein it was the court can, under this section, the court can direct person arrested to be present for identification parade on request of the investigating officer. So earlier section 9, it only provided for the admissibility of the identification of an accused, whereas by introduction of section 54A, now the court on the request of investigating officer can direct an accused to come for the go through the test identification parade. Now, section 54, I'll in short read section 54. Section 54 is where a person is arrested on a charge of committing an offense and his identification by any other person or person is considered necessary for the purpose of investigation of such offense. The court having jurisdiction may, on the request of the officer in charge of the police station, direct the person so arrested to subject himself to identification by any person or person in such manner as the court may think deem fit. Now, what is identification of person and property? Now, there are two types of identification. One, as we said, that is the test identification parade, and the second is the accused can be identified in the court. As I said, the test identification parade is a corroborative piece of evidence, whereas identification is in the court is more substantial as compared to the test identification. Now, the identity of a person may be done by observation of voice. Gait is by knowing a person by his walk. Special and unique features, utterance, fingerprints, footprints, photographs, and even by family likeness or resemblance. Now, these are the few methods by which you can conduct the test identification. Correct. Now, as we have already learned, or as we have already read, that whether the question comes to our mind whether this will be hit by Article 23 of the Constitution, which explicitly says about self-incrimination. So this test identification will not be hit by Article 23 of the Constitution, because as it does not mean giving testimony. So therefore, you don't have to worry about Article 23 of self-incrimination. This is out of the purview of Article 23, and it has been held on various occasions by the Apex Court that test identification parade will not be hit by Article 23 of the Constitution. Now, what is the evidentiary value of the test identification parade? Now, before that, I would also like to cite a case of Harraj Singh versus State of Bihar, wherein two purposes of test identification parade was observed by the Honorable Apex Court. One is to satisfy the investigating officer that certain person not previously known to witness was involved in the offense, and second, to furnish evidence to corroborate the testimony with the witness concerned tenders the witness concerned who tenders before the court. So these are the two purposes which were cited by the Honorable Apex Court. So basically, in short and in a nutshell, TIP is basically testing credibility and trustworthiness of evidence of the witness in the court. So now, what is, as I said, the evidentiary value is, it is not a substantive evidence, but only a corroborative. But only as a corroborative value. Now, what are the, for going to the actual test identification parade, and where the test identification needs to be conducted? First, there should not be any delay in conducting the test identification parade. For example, if A is arrested for the murder of B and A applies for bail, so when A is granted bail, there are chances that once he comes out of the jail, he may tamper with the witness, he may come in contact with the witness. So therefore, this will somewhere disrupt the investigation, and somewhere the test identification parade fails if taken after his release. So therefore, it is always advisable, and it is always by various circulars issued by the state of Maharashtra directing the police officer that they should conduct test identification parade whenever the accused is in custody. So therefore, the test identification parade should be conducted as soon as possible, and it is advisable that when he is in custody, it should be conducted. Now, this cannot be a reason for rejection of bail. If the test identification parade is not conducted when the accused is in bail, that cannot be a ground to reject the bail. The magistrate or the Apex or the sessions court will have to endure that when the bail application is heard, he should take the test identification parade before final hearing of the bail. So therefore, in short, there is no time limit given under CRPC or Evidence Act or any other act, but it has to be within a reasonable period, which has to be immediately. Now, on whose insistence a test identification parade is to be conducted? The test and identification parade is conducted on and only on the insistence of the investigating officer. As I said, the prosecution has to the onus is always upon the prosecution to prove its case. Therefore, and the investigating officer is the key, plays the key role. Therefore, to complete the chain of evidence, it is always the investigating officer who requests the concerned court to conduct the test identification parade. Now, here the question comes whether an accused can demand for test identification parade. Now, there is no provision under CRPC wherein an accused can demand for test identification parade. But the Supreme Court has time and again said that the court has wide powers under section 511, 311 of CRPC, wherein the court can bring the accused, and he can make the witness identify the accused in the court. But there is no provision under CRPC wherein an accused can demand for test identification parade. Now, what is the stage of test identification parade? The test identification parade is during the period of investigation. As I said, when an accused is arrested, if he's in custody, the charge sheet has to be filed within 90 days or 60 days. So before filing of the charge sheet, the test identification parade has to be concluded, and this forms the part of the charge sheet, the final report. And as I said, the IO has the prerogative to conduct, as he is the one who is charged of collecting the evidence. Now, one of the ground rule of conducting test identification parade is that it should not be conducted in front of police officer. So the police officer has to arrange for everything, but he should not be the part of test identification parade. Now, why this rule is made is because this, as soon as it is held in the presence of police officer, then the test identification parade will be hit by section 25, 26 and 162 of CR. In short, it says that any statement given before the police officer when the accused is in custody is not an admissible piece of evidence. So therefore, to keep this aspect out of the purview, the test a ground rule is made that test identification should not be conducted in the presence of police officer. So the procedure, in short, I'll explain. As soon as the accused is arrested, and if in his statement the witness says that an unknown person has assaulted the victim, or he has given the description of the accused, then if the IO feels that test identification is necessary, he'll make an application before the magistrate. Now, this magistrate can be a judicial magistrate or a civil judge, whereas by the circular of 1663, the powers are also given to executive magistrate and honorary magistrates to lessen the burden of the judicial magistrate. So therefore, an application is made before the judicial magistrate to conduct the TI parade. After seeking the permission, arrangements are made, place is fixed, and the witnesses. Now the TI parade can be conducted by the magistrate or before any independent person. So there is no such rule that it has to be conducted before any magistrate. It can be conducted before any independent person who are not connected with the offense. Now, it is always advisable, and there are there are many circulars issued by the state of Maharashtra that it should be conducted before the magistrate only. So now, as I said, when an application is made before the executive magistrate, the magistrate will grant the permission. Accordingly, pursuant to the permission, the police officer will make arrangements for the test identification parade. Now, the test identification parade is normally held in the jail vicinity. If at all the accused is suffering from any disease, or if suppose he is injured and he is admitted in the hospital, then in that case, if the police officer wants to call that accused for the TI parade, he has to first take the certificate of fitness from the concerned advocate. Once he gives the fitness certificate, then only he can compel or he can ask the accused to appear for the test identification parade. So once arrangements are done, then the witnesses, independent panchas are called. Now these panchas are specifically asked questions with regards to their knowledge about the incident, whether they have any link with the accused person, and all these things are noted down in the case diary. So now coming to the actual test identification parade, how the test identification parade is conducted. Now the test identification parade is very simple. Test identification means that the witness will identify the accused from the crowd. That means the accused is made to stand between between 5 to 10 independent and non who has no affiliation with the offense. He is made to stand in a line with those, and the witness is called in, and he has to identify who is the accused. Now there are few ground rules while conducting such exercise. First, if the accused is suppose, for example, he is having some marks on his body or face or anywhere on the body, then the investigating officer has to make sure that those marks are covered, or he has to make sure that other dummy persons who are standing besides the accused wears the same mark to some extent. So, for example, if an accused is having a mole on his face, then the investigating officer should make some arrangements to either hide it or to find some dummy witnesses who will have mole on their right cheeks. Second ground rule is that they should be identical in the features, height. Two persons cannot be same, I understand, but if suppose an accused is of 5'6", 5 foot height, then other witnesses, other dummies should be of the same height, more or less of the same height. They can be 5'1", 5'2", but they should be of the same height. Because sometimes what happens, the witnesses describes the accused or the unknown person by their features, by their height, by their color, by their skin color, by their way of walking, by the way they talk. So in that cases, the police officer has to keep these things in mind. Now, once the accused is made to stand with other dummies, he can raise objections at any time. That objection should be recorded in the case diary. The accused is at liberty to change the clothes if he desires to. The accused, all the objections, everything has to be recorded in the case diary, which is recorded during this process. And this complete procedure has to be recorded. So now, moving to the next point, one of the feature is that in one of the cases, I would like to cite one of the cases wherein it is a case of Abdul versus NCT. I'll just read out the relevant facts. No. So this is a case where there was an attack on the parliament. So in this case, the accused had went to Karol Bagh in Delhi to hire an ambassador. So in that process, they met that agent. They spoke with him for 40 minutes. And after that interaction, they hired the ambassador. So the court said that 40 minutes, the Supreme Court, the Apex Court, is said that the 40 minutes is enough to hold that the attest identification is a corroborative piece of evidence. And similarly, in a Malka Singh case, it was a rape case. The victim a victim minor was raped at night in dark night. So the test identification parade was questioned by the defense. In this, the court said that the distance between the victim and the accused was very less. Therefore, the test identification is valid and it is a corroborative piece of evidence. Similarly, in one of the cases, in Mohan Singh versus Bihar, the identification was also done by the voice, because sometimes you can recognize a person by the voice. In such cases, it is mandatory that the TI parade should be conducted immediately so as to avoid the fading of memory of the witness. Now, there are certain instances where the identification is also conducted by photographs. Now, in cases under Section 22 of Terrorist and Disruptive Activity Prevention Act 1987, it is mentioned under Section 22 that where a person is declared as a proclaimed offender in a terrorist case, the evidence regarding his identification by witness on the basis of his photographs shall have the same value as that of the test identification parade. So there is a special provision made under made under Terrorist and Disruptive Activities Prevention Act, wherein credibility is given to the identification by the photographs. Now, what are the do's and don'ts of test identification parade? So as I said, test identification parade is very simple. An accused is made to stand in a line with other dummies. Those dummies should be in a ratio of 5:1, minimum of 5:1, or maximum of 10:1. The witness is called in. If suppose there are more than 2 to 3 witnesses, then the witnesses needs to be called simultaneously, and the IO has to make sure that 2 witnesses do not mingle with each other. So therefore, when one witness comes and finishes his test identification parade, the whole process is again reshuffled. The accused is made to stand in different row, different number. The accused is free to change his dress. The jailer has to make sure that the appearance of the accused should not change. So therefore, if all these things are considered, the time of the delay in taking TIP is very, very important and crucial at the time of trial, because these are the points which the defenses attacks at the time of the trial. So what are the do's and don'ts of TIP? First, it should be held soon after the arrest, and as I said, it is not a ground, though there is a ground rule that it has to be held soon after the arrest, but there is no ground that it is one of the ground for rejection of bail. The police should always take steps through magistrate and not through any independent witnesses. So this will basically, so there are 2 types of statement. Apart from the TI parade, I want to just focus on one aspect, that is any statement. As I said before, any statement given before the police officer is inadmissible and is hit by section 25, 26 and 162 of CRPC. So there is another way of taking the statement, that is under section 164 CRPC. Under 164 CRPC, the witness is made to appear before the magistrate. The magistrate takes down the statement of the witness, and that is a credible piece of evidence. So therefore, in such cases also, where the TIP is conducted, it is advisable that it has to be conducted. It should be conducted before a magistrate. Now, as I said, before conducting TI parade, it is advisable that the witnesses 164 statement should be recorded. Now, these 164 statements are mostly nowadays mostly are recorded in rape cases, in POXO cases, and in 354 outraging modesty of a woman. These cases, to some extent, they are also registered. They are also recorded under murder cases. Whereas under special act like MCOCA, there is a special provision where a confessional statement has to be recorded, and the admissibility of confessional statement is already upheld by various judgments. For example, Tufan Singh under NDPS Act, Tufan Singh is there. Under MCOCA, a different act is there. So that is that apart. So it is advisable that 164 statement should be recorded before conducting test identification parade. Now, one of the point is that the witness should not identify should also identify the accused in the court, as the TIP is not a substantial event. So at the time of trial, the court has the power to ask the witness to identify the accused in the court itself. So if for some reason he has identified the accused in the test identification parade, whereas he fails to identify the accused during the trial, then the later part will bear the relevance, because that is a substantive part of evidence, and it is before the magistrate who is conducting the trial. What are the don'ts of TI parade? The don'ts are that there should not be delay. It should not be held in presence of the police officer. There is no bar that the private person should not conduct TIP, but it is not advisable. Also, the suspect should not be shown to the witnesses. No photograph of the suspect should be shown to the witnesses, and the photographs of the accused should not be published in the newspaper. Nowadays we can see that the police officers are publishing the photographs of the accused persons in the newspaper as soon as they are arrested. So this is not at all advisable, because the test identification, the credibility of the test identification will be hit by this to some extent. Now, what are the as I said, what are the general procedures? I have explained in short. If something is left, I'll tell. Now, there are rules made with regards to the identification of a person and property. Those rules you can read from Criminal Rules of Practice and Circular dated 1990. Under Rule 34 and 35, the identification of person and properties are given. And today I will not go through the rules, but the procedure followed is narrated in these rules. Now, as per the circular issued by the state of Maharashtra, even executive magistrate and the honorary magistrate can conduct the TI parade. Now, since the TI parade is held in jail, the investigating officer has to have to keep certain points in their head. First is that they will have to inform the jailer that they are about to conduct the TI parade. Second, the jailer has to make sure that he has to prohibit any change in the appearance of prisoner. That is, for example, beard not to be shaved or grown, and same clothes to be worn at the time of the offense. And if the jailer has to make sure that if the prisoner is injured or if he is hospitalized, then the certificate from the doctor has to be obtained, and then only he can allow for such test identification to be conducted by the investigating officer. If in certain cases, if the injured or if the suspect cannot be taken to the jail, or in certain cases if he is hospitalized, then in certain cases, only in certain cases, the test identification parade can be taken within the premises of the hospital. But you can rarely see such cases. So in short, as I said, So I'll sum up with whatever I have said. Test identification parade is very simple. Test identification parade is ascertaining the identity of the accused by testing the witness, whether he is trustworthy or whether his version can be trusted. The test identification is not a substantive piece of evidence, but it has a corroborative value. The test identification parade is conducted by the investigating officer in the presence of the magistrate. The magistrate can be judicial magistrate, civil judge, executive magistrate, or the honorary magistrate. The test identification parade is nothing but linking the chain of evidence. The test identification parade has to be done within the premises of the jail. There are certain rules while conducting test identification parade, which I have narrated just now. The test identification parade, one has to keep in mind that the accused is an unknown person. When the witness gives the statement, he has to specify that he is not aware of the identity, or he is not known to the accused person. Then only test identification parade can be conducted. There is no test identification parade if the witness knows the accused. Now, the test identification parade, the police has to keep in mind that the accused is not mingled with the witnesses. Two witnesses are not mingled with each other. The police are not part of the test identification parade. The test identification parade has to be as per the rules laid down by the under section 54 A of the CRPC, and under the rules under the circular 1990 issued by the state of Maharashtra. So these are the few points, and there is nothing apart from this. If at all you want to, I can cite few judgments. So in Asarif versus State, the apex court held that the identification is always a matter of opinion or belief. With regards to criminal offense, is identification as a twofold object. First is to satisfy the investigating authorities before sending a case for trial to the court, that the person arrested but not previously known to the witness was one of those who committed the crime, or the property concerned was subject of such crime. Second, to satisfy the court that the accused was the real offender, or the article was concerned with the crime which is being tried. Also, one point which was left is how to identify the properties. Now, the identification of the property is in similar fashion. The property which is in question is brought before the court, before the magistrate. Five other such properties, dummy properties, are placed and mixed with each other, and the witness is made to identify the property in the court. So this is as simple as that. Now there is one more case law where in the case of Hasib versus State of VR, the apex court said that now identification parades are ordinarily held at the instance of investigating officer for the purpose of enabling the witness to identify either the properties which are the subject matter of alleged offense, or the person who are alleged to have been concerned in the offense. Such tests or parades belongs to the investigating stage, and they serve to provide the investigating authorities with material to assure themselves if the investigation is proceeding on right lines. It is accordingly desirable that the test parades are held at the earliest possible opportunity. Early opportunity to identify also tends to minimize the chances of memory of the identifying witness fading away by reason of long lapse of time. But much more vital factor in determining the value of such identification parade is effectiveness of the precaution taken by those responsible for holding them against the identifying witness having an opportunity of seeing the person to be identified before they are paraded with the other persons, and also against the identifying witness being provided by the investigating machinery authority with other unfair aid to assist. So in short, the apex court has also said that it has to be done at the earliest point of time. So in nutshell, this is the test identification parade. As I said, the criminal investigation initiates with lodging of the FIR. Once the FIR is lodged, the police has to continue its investigation. During the investigation, they are at liberty to either investigate the substantial evidence or the corroborative evidence. Now the substantial evidence, as I said, are the direct evidence, and the corroborative evidence are the test identification parade, the call records, the chats, the video CCTV footage. All these are the substantive part of which is also called as the circumstantial evidence. The last scene also is also one of the circumstantial evidence. Suppose if A murders B and throws his body in a ghat, there is no eyewitness to the crime. If C sees A, or if C sees A passing from that place of offense, then that is called as the place of last scene theory. So in this case also, a test identification parade is very, very crucial, because this is the only piece of evidence which can connect the accused from the date of from the place of offense, and which can give an inference to the prosecution to make a case, make a strong case against the accused. So in nutshell, all and all, this is the test identification parade. It is not for the defense to go into test identification parade. The defense has to only see whether the rules under the CRPC while conducting test identification parade is followed properly, and this the defense can always raise these objections at the time of trial. The defense can always cross-examine the witnesses who appeared before for the test identification parade. So all and all, this is the prerogative of the investigating officer. The guidelines issued by the Apex Code by various circulars needs to be followed, and the prosecution, as I said, the onus is on the prosecution. The prosecution has to prove its case beyond reasonable doubt, mostly in cases of dacoity.
Does handwriting also fall under the ambit of TIP?
Let us read section 311. All these corroborative evidence. There were so many judgments on DNA testing, as you said, handwriting. So this section 311A was introduced, and which says that if a magistrate of first class is satisfied that for the purpose of any investigation or proceeding under this code is expedient to direct any person, including any accused, to give specimen signatures or handwriting, he may make an order to that effect. And in that case, the person to whom the order relates shall be produced or shall attend at the time and place specified. So basically, 311 gives power to the investigating officer to take specimen signatures. TIP, if there is a separate provision, this may not be a part of the TIP, because TIP is mostly the physical appearance. It can be the way you walk, it can be the way you talk, it can be the appearance, it can be by the looks, or by any unique feature or sign on the body. So there is a special provision for handwriting.
Okay, sir. Okay.
Which is 3118.
Sir, I have two requests. One
Yes.
is you can re-describe those criminal rules which you mentioned about criminal practices where TIP is to be conducted. And
Yes.
second thing is, sir, if you can re-narrate the two citations which you mentioned at last. I think something about Asiraf versus State and Hasid versus Bihar. So there was a slight audio issue because of which I was not able to exactly.
So basically, I'll tell you in a nutshell. I read the same thing which I explained in one line. That Supreme Court has said that it has to be done immediately without any delay. Why? For one reason is that there are chances that the memory of the witness might fade away. Second, there are chances, if you give time to the witnesses, there are chances that sometimes the relatives of the accused can mingle with the witnesses. So therefore, to avoid all these circumstances, it is always advisable that it has to be done immediately after the arrest. Basically, this is the case. There is also one of the case where the Supreme Court has said that though there is no provision under CRPC that an accused can demand for TI parade, but still an application can be made, and an adverse reference can be drawn by the judge if that is rejected by the prosecution. So there can be one question that can you compel, as earlier also was asked to me, can you compel someone to give to subject himself for TI parade? You cannot compel. You can also reject it. There is no provision under CRPC which compels the accused to give TI parade. But then in such cases, the magistrate during the trial can take an adverse inference, and it may go against the accused. So that is the thing.
Okay, sir. So the next question, Sumedha wants
If
to
you
ask.
want the rules also which you said, I'll share it with you. The rules, all the rules under that circular, I'll share it. Yes, madam.
Sumedha,
Yes, am I audible, sir? Okay, so I wanted to ask what is the position of test identification parade in NDPS cases where there is
There is
no
no test
victim or
identification parade. There is no test identification parade in NDPS cases because it is a special act. It is a
Yes, sir.
special act and it is governed by the special rules, and separate rules are laid down under that. For example, any NDPS case starts with the Panchanama. For example, if the police officer gets a tip that XYZ dealer will be selling MD, mephedrone or ganja or charas at such and such place, then the police writes down that information in their information note. They send it to their officer. They seek permission to raid that particular premises, or to check that to raid the particular person. Then a team is formed. The person is intercepted, and he is made avail of his right under section 42 or section 50 of the NDPS Act. And then the substance and everything is taken into custody and sent to forensic. So in this case, this is the procedure. This is the
Okay, sir.
procedure.
Thank
So
you.
there is a separate procedure under the special act. But if you
Thank you,
take
sir.
MCOC Act, the test identification proves to be a very, very vital piece of evidence. So even though corroborative, but it proves to be a vital piece of evidence.
Okay,
Yes.
thank you, sir.
In case there is a mob lynching
Yes.
and many people are involved
Hmm.
in a particular crime.
Yes.
So how does the test identification parade is relevant in that case?
It is. These are the cases where test identification is very, very relevant, because, for example, if there is a riot somewhere, or if there is a riot with regards to hurting the religious sentiments or XYZ political riots, then in that cases, it is very obvious that the persons are unknown. Most of the time, they are karyakartas of some affiliated parties. So most of the time they are unknown persons. So in this case, it is very, very important to conduct a test identification parade. Suppose if in most of these cases, there may not be a test identification parade also, because the complainant sometimes is the police officer sometimes is the complainant. So in those cases, it is difficult to conduct the test identification parade of the police officer. A test identification parade of police officer is nowhere mentioned under the CRPC. But if suppose an independent person from the place of offense gives the complaint, then in that case it is a very crucial piece of evidence. और normally अपन क्या करते हैं, ये जब lynching होता है, rioting होता है, normally the police officer they suo motu register the FIR. So in these cases, generally, practically, you don't see test identification parades. But a test identification parade of the witnesses can be done, not of the complainant. If suppose someone is passing by and he witnesses the crime or the writing, the test identification of that person, that witness, is very, very crucial.
Thank you.
okay. Sir, the next question is, at what stage a TI parade should be conducted? It
Before
should be
investigate. During, as I said, IO has a limited period. If the accused is arrested, then he has either 60 days or 90 days. So it has to be done within those 60 days or 90 days. If he is released on bail, then the charge sheet has to be filed within reasonable period. But then if there is delay in recording the test identification parade, then he has to give reasons why there was a delay. For example, in one of the cases, the IO kept on making application to the concerned judge, but the judge was busy in his judicial work. Therefore, he could not come for the test identification parade, and therefore it was delayed. This ground was raised by the defense during the trial, but the court said that as it is a corroborative evidence, there are other material also which connects the accused to the crime. Therefore, solely on the basis of delay, the evidence cannot be rejected. So there are cases that the court has also appreciated other evidences, and then based on that, found that it held that observed that TI parade is also a corroborative evidence in light of other evidences. So mostly it has to be done before filing of the charge sheet during the investigation stage, because see, it is a very simple thing. Once charge sheet is filed, the police seizes with the case. Then the cognizance is taken by the magistrate. As long as the police has the case, the investigation is in the hands of the police can can conduct the TI.
Okay, sir. So the next question is whether TIP is applicable to the entire of India.
Yes, Evidence Act, CRPC, and IPC are central.
Yes,
Not
sir.
they are governed. They are all the states. They follow the same procedure. They follow the same act.
Okay, sir. So the next query is inquiry under criminal contempt of court under Rule 12A and 12B of Bombay High Court rules governed by CRPC.
There is a contempt of act, separate contempt of act. All the procedures are governed. All the criminal procedures, all the acts, the procedure is laid down under CRPC. The effort should be made that it does not overlap with the procedural law which is provided under CRPC. But the contempt act is totally different. It has its own set of rules or a set of facts.
Okay, sir. So the next question is what is the possibility for the accused to get bail after he identified in TIP by the witness?
Uh, uh, bail is always a discretion of the court. And so the evidence, the TI parade has to be appreciated in light of the other evidences also. For example, if the accused, if A says that B assaulted C with stick, but during the TI parade, he says that he's the person who assaulted the accused with a knife. So there is a discrepancy. So these are all points of arguments. This is how you argue. You create a reasonable doubt within the minds of the judge so that he can grant you bail. But the bail is a discretion. It has to be seen in the light of other evidences also.
Okay, sir. Sir, the next question is it compulsory that a criminal MA, miscellaneous applications, is supported by an affidavit? What if it is not?
See, I don't know which MA you are talking about, but generally, if you are filing a bail, there is no need for verification because the accused is in custody. So you can file it on behalf of all you need is the wakalatnama and the stamp of the jailer on the wakalatnama of the accused, which gives you right to appear on his behalf. That is sufficient in bail matters. Whereas in anticipatory bail, where the accused is at large, in those cases, you generally annex the verification. That verification states that the above I have gone through, my name is so and so, age, address. I have gone through the contents of the application, and it is true and to the best of my knowledge. So this is just a declaration. So these are all these rules you can find it in the appellate side rules. If the matter is before the original side, there are separate rules, original side rules. So you will find it there. But
Okay.
it has to be mostly it has to be verified. An affidavit saying that I have understood whatever is written and it has been explained to me in my vernacular language.
Okay. So the next question is, can a child do the test identification parade? If yes,
Yes.
then are there some guidelines?
The child can do the test identification parade. The guidelines are the same. There was in fact a case where a 13-year-old girl was made to identify her rape suspects. The Supreme Court said that though she is a minor, but it is a valid test identification. The rules are the same. Just we have to make sure that the environment has to be suitable for the child. She has to be made comfortable whenever she appears before the court. All those basic rules which are followed normally when she comes to give witness also, that is followed during test identification. So there are separate guidelines also, I think, issued with this regards. If at all any minor is coming to for the test identification period, what are the precautions which the police needs to take? So
Okay.
whether she can be accompanied by parents, if she is minor, she can be accompanied by one of the parent, or what if she starts crying, whether anyone can enter, whether she can be given water. So basic things. All these guidelines are there. You can find it. There are circulars to this effect.
Okay.
Hmm.
Sir, one participant is asking how criminals are coming out when we have so much legal protocols such as TIP, evidences, arguments, etc. Is it because of the weaker side of PP and stronger side of the lawyers who argues for the criminals?
No. In fact, the courts are now overburdened. If you want to see, there are recently, if you read Antil's judgment, Antil versus State of Uttar Pradesh, I think. Recently, the Supreme Court has framed certain guidelines wherein bail can be granted. The reason the Supreme Court framed such guidelines because the jails are getting overcrowded. See, ultimately, if at all a case is registered against an accused, the fate will be decided after the completion of trial. Till the trial is completed, if even if the FIR is registered against any person, he is not an accused. So he cannot be called an accused unless he is convicted in the trial. So therefore, bail is always a discretion. What are the conditions on which the bail can be granted? First, that the offense is not grievous, that he cannot be released. Second, that once he is released, he will not tamper with the witnesses. Third, he will not tamper with the evidences. Fourth, that he will cooperate with the investigating officer once released, after or once conditions are imposed by this court. Fifth, he'll regularly attend the trial and he'll cooperate with the trial with the court. These are the only grounds on which the bail can be granted or can be declined. So there is no state jacket formula for that. If at all there are some cases in Bombay jurisdiction, you can see there are more of white collar crimes. There are scams. There are 420 cases, 468 property, 468 cases, 471 cases, property dispute. Whereas if you go outside Bombay in small villages, you'll find more of bodily offenses like 307, 324, 326, 302. So there is a difference in normally in a civil dispute, in a cases where this dispute arises out of property, then there are other remedies also. There are other civil remedies where you can recover your amount. So this cannot be, time and again the apex court has said that criminal law cannot be used to twist the hands of the other party when there are already other provisions or other remedies available under the civil law. So it all depends on the facts of the cases. Thank you.